All right, well, good evening, everybody. Tonight we're going to talk about business entity types and what it means to you as a business owner and what it could do for your business. Before we get into that, first, who am I, right? Who's this guy up here talking to you without a suit and tie on? Because Don asked me to come casual tonight, so I figured I would. I'm Mike Terkanian. I'm an attorney in the Bucks and Montgomery County areas. I specialize in business, intellectual property, and technology law. Prior to becoming an attorney, I was a software engineer for 15 years, but even further back than that, I've actually been writing code since I was 9. So Cody and I talk quite a bit about software and software applications. Let me just tighten this up. There we go. Is that better? All right, cool. So that's a bit about who I am. And also this gentleman over here to my left, the dapper-looking gentleman in the blazer, that's Nathan Carr-Whealy. He's also a fellow attorney, a very good friend of mine, a colleague, and we do a lot of work together in business formation and in the business world. And what we're going to discuss tonight, several things. First, we're going to review the basic entity types, including the process of setting them up, the liabilities you could face, and the tax implications. We're going to discuss the pros and cons of each type, and we're going to discuss, there's a lot of feedback there. There we go. We're going to discuss possible basic tax strategies with your entity type choice. And there will be some disclaimers as we go throughout this tonight as well. And then we're going to have a Q&A session at the end and understand something. I cannot answer specific tax questions because I am not a tax attorney, and I will say that several times throughout the night. I can only give you basic tax information related to entity choice. So if you have specific tax questions about your business, I will not be able to answer them, but I might be able to point you in the right direction to get your answer. So, disclaimer, first and foremost, and I know we did this earlier, but I have to do it again for reasons I'm sure you can imagine. Nothing in this presentation or the following Q&A session will create an attorney-client relationship between us. This presentation is for general information purposes, and nothing in this presentation is meant to answer your specific questions or legal needs. Nothing in this presentation is to be considered legal advice, as the information may not reflect the most current legal developments. There are no guarantees of any results with any of the information provided, and you are encouraged to consult with your attorney prior to acting upon any of the materials presented tonight. Any questions about that? Make sense? Okay, let's move on. What if I am your attorney? Well then we should talk. I'll start the clock now. All right. So, standard entity types, all right? This might be a review for some of you. For some of you, it might be brand new, and you might not even realize what's going on. So, the first and foremost, the basic of the basics is the sole proprietorship. And this is where an individual is running a business and has not registered that business with the Secretary of State. We'll get into that in a little bit. Partnership, similar to a sole proprietorship, but it's two or more people, two or more individuals running a business under an agreement. Notice it's italicized because that's important. There has to be an agreement, but has not registered with the Secretary of State. That agreement does not have to be written down. It could be oral, but it is an agreement between two people to run a business, or two or more people to run a business. LLC, or limited liability company. This is a separate and distinct entity relative to its members. So if you are the quote-unquote owner of an LLC, that is a separate entity from you as an individual, and that has been incorporated or registered through the Secretary of State. So you filled out a piece of paper, sent it into the Secretary of State and said, I want to form this company. This company is a distinct, separate entity from myself, and you have to treat it as such. Again, we'll get into that in a little bit. And then there's the corporation, which everyone's familiar with. It's a separate and distinct entity relative to its board of directors and shareholders that has been incorporated through the Secretary of State. Again, if you own stock in IBM, while you're technically a quote-unquote owner in IBM as a shareholder, you have nothing to do with IBM getting sued for any violations of any laws or something like that. Now, some of you have already asked me earlier, or I'm sure you've heard of what's known as an S corporation. This is not an entity type. It is a tax election. And we'll talk about what it means a little bit later on, okay? But an S corporation is not an entity type, for those of you who might be confused as to why we're not talking about that yet. Okay, so let's talk about starting up, right? How do you start up a business? Well, each business type starts up a little bit differently, and we'll get into that now. So we have a little bit of audience participation here. So let's talk about the difficulty of starting up. For sole proprietorship, it's really, really, really easy, okay? And we're going to go through that. We're actually going to start a business here tonight. For partnership, it's pretty easy as well. Limited liability companies are slightly more complicated, but not really too difficult. And then corporations, it's not overly difficult, but there's a lot of work involved in starting a corporation. So let's start up a sole proprietorship. I need a volunteer. Anybody? Not you. All right. Anybody else? Come on. There you go. All right. Stand up. All right. Remind everybody of your name. All right. Tom. Now, yeah, please. Go to the microphone, Tom. All right. Tom, before you leave that microphone, you're going to start a business. How about that? Okay. That's how easy it is. Okay. Wow. Okay. All right. So step one, you've already done. You stood up. All right. Now, give me a name for your new fake company.
Wet Socks.
Wet Socks. All right. So we're going to do Wet Socks. That's the name of your company.
Yes.
All right. Step three. Somebody give Tom a pen or a pencil. Oh, you have one in your hand. This guy's ahead of the game. Great. All right. Now, turn around and show it to the person next to you. All right. So you have your pen or pencil there, right? Now, tell them you want to sell it to them for $1.
Can I sell you this for $1? This pen, beautiful pen. Look at this. It's got a cap. Oh, wait, it doesn't have a cap. It has a plunger. Oh, the plunger doesn't quite work. But anyway, it's still a great pen. It's got beautiful ink, and it's going to last for a really long time.
Oh, he's really owning this. Awesome. Okay. Yeah. So you went there and you tried to sell a product to somebody. Congratulations, you're in business. Okay. It is that simple to start up a sole proprietorship. Now there's, filing with your local township and things like that. We'll get into that stuff later. But in reality, a sole proprietorship is nothing more than a person who says, I want to go into business and starts marketing themselves as a sole proprietor. So you're now Wet Socks, the sole proprietor of Tom, and you sell pens. Okay. That's really how easy it is to start a sole proprietorship. But there are complications with that, which we'll get to in a little bit. Yes? Sure. You can sell anything you want as a sole proprietorship. There are restricted services, like you can't be a sole proprietor doctor unless you have a medical license, right? But other than some restrictive services, cleaning or, marketing services or something like that, you can sit down, thanks. You can just start up and say, I'm starting a business, and you have a sole proprietorship. So it requires nothing more than the act of doing business, i.e. buying or selling, whether it's a service or a product. As long as you have a system for keeping track of your revenues and expenses, you can wake up tomorrow and start a sole proprietorship. And in reality, if you don't have a system for keeping track of your revenues and expenses, that's more of a tax issue than anything else. Let me go back. There's no registration necessary with the state or the IRS to do this. You don't have to have an EIN. In fact, you don't want an EIN if you're going to start a sole proprietorship. You may need to register with your local township, but again, that's for tax purposes. It's not for registration purposes. Worst case scenario is you'll have a business, you'll just owe some back taxes if you don't do that, but don't owe back taxes. Okay, so before I go on, any questions on sole proprietorship? Yes?
I'm sorry, please come to the microphone if you have a question, or take the microphone to your...
Can you issue a receipt for any revenue you receive from your services?
A receipt like to a customer? Sure, why not? Right, if I were a customer, I would want a receipt. So sure, just again, if you put it as a trade name, right, Wet Socks or whatever you want to call it, it's a sole proprietorship that you are the owner of. But it leads to liability, which we'll talk to when we get to the next part of this. Sir.
Side note, if you do want an EIN number, you can only get 2 of them.
What's that?
You can only get 2 of them from... Quick side note, if you do want an EIN number, as a sole proprietor, you can only get 2 EIN numbers.
Under your social security number, that's correct. Okay. General partner. Oh, I'm sorry, there was a question back here. Well, we'll go with this gentleman, and then we'll go over here.
Sorry. I've understood that there's an advantage to getting an EIN as a sole proprietor so that when you're giving that out to customers to be able to generate, so that they can generate a 1099, they don't have your social security number.
Right. That's an advantage to doing it, yes, but it's not required. Yes.
If you are a contractor working for a big company, is it still counted like sole?
So you're talking about independent contractor status? Technically, one of two ways. You can do where you individually, under your social security number, are an independent contractor to that business, or you can do corp to corp, so that you have an LLC or a C corp registered, and then that business is paying your LLC, and you are working for your LLC as an independent contractor to that business. The difference is when you're doing business in the general public, technically, I guess it could work for the IC, but when you're doing business in the general public, there are liability issues that you have to take into account. And again, when we get to liability, we'll discuss that. But yes, you could, when you're an IC, generally most people that are ICs are doing it on an individual basis. And yes, they're technically a sole proprietor when they do that. Nate, anything you want to add to that? Great job, Nate. Thanks. All right. General partnership, unless there's any other questions. All right. General partnership. Now I need 2 volunteers. 1. Okay. I need a second. Sit down. I need another volunteer. All right, right over here. All right, both of you, please stand up. All right, look at each other. All right, say these words. Let's go into business together. Let's go into business together. Okay, now pick up a napkin, and let's pretend it's a partnership agreement that you just drafted, and give it to the other side to sign. All right, there you go. You're now in business as a partnership. Good job. All right. Again, a partnership. Please sit down. A partnership, it's the same as a sole proprietor, except obviously 2 or more people, and it requires an agreement between 2 or more people to go into business together. And that's really it. You don't have to file anything with the government. You should, but you don't have to. You just need an agreement between the 2 of you, or however many members of the partnership there are, how many partners there are, to talk about how you're going to run the business, right? How much money you're going to have to put into it. What's the exit strategy to get out of it? What are you going to do? Who's going to have what percentage of ownership? So if one person puts in 100 grand and another person puts in 20 grand, you probably don't have a 50-50 split, right? So you have to talk about those kinds of things in the agreement. And again, it's because it's between 2 or more people. If it was a sole proprietor, well, you don't need that agreement because you're just, it's just yourself. So there's no registration necessary with the state or the IRS, although you can file partnership paperwork. And again, you may need to register with your local township for, earlier I said it was just tax purposes. There are actually 2 reasons to do it. Number 1 is tax purposes, and number 2, every township wants to know what businesses are running out of their township, and it's your business privilege paperwork. So you have to file that with your local township, letting them know that you're running in that township. Okay, LLCs. Now, this is much different. We're not going to do volunteers here because, well, it's much different, okay? So the first thing you do to start up your LLC is you need to register, and you can do it, the first 2 you can do in either order. You register your EIN, Employer Identification Number, or a tax ID with the IRS. And the reason why is because, as I said earlier, an LLC is a distinct and separate entity from the people who, quote unquote, own the LLC. So, therefore, you're not using your Social Security number. You're using the tax ID provided to you by the federal government. Then you file the Articles of Formation as opposed to the Articles of Incorporation. It's Articles of Formation with the Secretary of State. Okay? And what you're doing is you're telling the Secretary of State, okay, we are creating this business entity. It is a separate entity from the members of the business, and therefore that we're going to do business under this name. And we're putting everybody on notice when we use our name in the business world that we are an LLC. And again, when we get to liability, it's very important why we do that. If there's multiple members, this is not necessary, but hugely, I suggest you do it. Draft and sign an operating agreement. This is similar to your partnership agreement. In the LLC world, we call it operating agreement. And it does essentially the same thing. Who's a member? Who can get out, how you exit out of the membership, who's putting what money in, your capital contributions, are they reimbursable, are you going to be doing distributions, dividends, things like that. You had a question, sir?
Member LLC.
Yes.
Please, I'm sorry, please come to the microphone.
If you're a single member LLC,
Yes.
is there an operating agreement required? And who would it be with?
There is never an operating agreement required for single or
Right.
multiple member.
Okay.
Although if you don't have one for multiple member, you're setting yourself up for disaster. As a single member LLC, is an operating agreement necessary? My answer is yes, and I'll tell you why in a second. I'm curious what Nate thinks. Okay. Thanks, Nate. All right. So the reason is, and when we get to what we call piercing the corporate veil, okay, which is the way that people can get through the liability protection of your LLC or corporation, the more information or the more things you have to show that you treated the business as a separate business, the better. If you're a single member LLC and you don't have an operating agreement, or let's say you do, you're a single member LLC and you do have an operating agreement, and someone wants to sue you personally for action X, whatever that might be, and you can show that those actions were consistent with the operating agreement of that company, that's going to be better for you to protect you from personal liability.
So that brings up the next question. How do we do that? Is that a complicated form? Is it a form or is it an actual written agreement?
You can do it one of two ways. You can hire an attorney to do it, which obviously would be the better way to do it. No, I'm not trying to sell myself here, but that's reality. Or you can go online. You can find free templates that you can download and try to fill in the blanks as best you can.
I just have one more quick question.
Sure.
When you form an LLC, there's a question about the type of business, and I think they apply an
That's correct. Yes.
SAIC number. Does that restrict? Well, let's say you do a bunch of different things under this LLC.
Yeah.
Is there something you have to go back and fill out, or you just go ahead and do it because you're not doing the same thing?
Generally, there are, as I said earlier, there are restricted services that you can't perform, like medical, legal, right, financial, without having the proper licenses, right? You can't be a real estate agent unless you have the proper licenses. So when they're asking you on the form, is it wholesale, right? Is it maritime? Are there things like that where you have to have specific licenses? That's why it's asking you. 99% of the time, the answer is probably other, and then you choose service or product, right? And that's really what it comes down to. And then when it asks you what type of business you're doing, the answer is very simple: any lawful business.
Okay.
Really, that's what it is. Any lawful business, and it's lawful because it's not restricted.
I don't want to steal all the time, but I do
No,
have
by
one
all
more
means.
question. Can you have a DBA doing business as
Yes.
under an LLC?
Absolutely,
Okay.
You must have one. I'll explain that in a second. All right, so we have the operating agreement. Now, if it's applicable, it's interesting enough, you just said it, you want to register a fictitious name. Now, this is where a lot of LLCs fall short, and let me tell you what the complications here are. Again, we haven't gone over liability yet, but let's just suffice it to say that if you own an LLC, you're personally protected. If you own a sole proprietor and you get sued, your personal assets are at risk, okay? The fictitious name is a very important thing that people don't quite understand when it comes to the LLC, creating an LLC. So Wet Sox, we'll go back to that. We want to create Wet Sox LLC. We file our paperwork with the Secretary of State. Sure enough, there we go, Wet Sox LLC. And that's all we do. We don't do anything else, no fictitious names. What do we put on our business cards? Wet Sox. What do we put on advertising? Wet Sox. What do we put on our website? Wet Sox. Without the LLC. Do you know what happens? What's that? The veil could very well disappear because you did not put comma LLC at the end. Therefore, you haven't put people on notice that it's an LLC, and you hadn't filed a fictitious name with the Secretary of State to let people look up Wet Sox without the LLC. And there's a very strong argument that the corporate veil has now disappeared because you're acting as a sole proprietor under the name of Wet Sox, not Wet Sox LLC. Okay? So what you do is you register Wet Sox LLC and then a DBA or fictitious name of just Wet Sox, if that's how you're going to market yourself. Okay? Very unlikely that that situation would come up, but for $70, make sure it never comes up.
Please come to the mic.
So if I understand you correctly, what you've just said to us is if you form an LLC, the Wet Sox
That's it.
LLC,
Yes.
and you register a fictitious name, Wet Sox, without the LLC.
Yes.
Okay. It's my understanding that the purpose of doing the LLC is to notify the public that you are a limited liability company.
Yes.
Using a fictitious name, isn't that circumventing that part of the corporate law?
It is not. And the reason is because if I were to go onto the Secretary of State's website, PA Corp Search, right, and search for a corporation and type in the name Wet Sox, if I registered it as a DBA, it would come up under Wet Sox LLC. Therefore, I had to do my due diligence to make sure that I knew what type of entity you were, and I could search that online. You understand what I'm saying?
Yeah.
All right. So if I didn't register Wet Sox as a DBA, it would come up, and therefore I would be under no notice that it was an LLC.
A couple different, sorry, can you have a couple of different fictitious name under one?
People do it all the time, absolutely. So someone had asked a question earlier about setting up a real estate holdings company, and one thing you can do, it's not the way I would do it, but one thing you can do is set up real estate holdings LLC, and then each property is a separate DBA under that. I personally wouldn't do it that way, but you can, and there's nothing wrong with doing that.
I don't mean to beat a dead horse here, but
Either way.
What happens when, like Google search, they might say Wit Socks or Wet Socks or something like that. It's crazy to try and do DBAs for all of these, right?
It's really comes down to what you put on your marketing materials, right? So let's say you have a website and it's Wet Socks, wetsocks.com, but in the footer you put Wet Socks LLC. That's probably enough, right? It's the business card that doesn't have the LLC on it, or the billboard on the street that doesn't have the LLC. That's where you could. I'm not saying you will, but you could run into trouble. Again, for $70, protect yourself and just don't let that happen.
One of the things that was suggested to me in that situation is to put at the bottom of your business card and your website. If the website is Wet Socks, at the bottom which should say owned and operated by Wet Sox LLC.
That's correct. Yes. Okay. But if you didn't register the name, that would be difficult to do because it's not owned by anybody.
Obviously, yes.
Yes.
So one small question I have, is it the same with businesses that are incorporated?
So like Inc., INC?
Yeah.
It is, yes.
Okay.
Yeah, that's why we have the INC at the end. Yeah, okay. So again, it would be the same thing where you'd want to register the fictitious name for the corporation.
Okay, great. Thanks.
Sure. One more. Okay.
So the DBA doesn't have to be similar to the name of the business. It could be something.
Anything you want. Anything you want. And I'll tell you the perfect example. Dry socks, yes. The perfect example is when you go and open up a business, right, a sole proprietorship under your Social Security or whatever, and you want to do a DBA app from yourself. Well, my name is Michael Terkanian. If I want to open up Wet Socks Laundromat, right, I would do a DBA Wet Socks Laundromat. What's that have to do with me as an individual? Name-wise, right? So yes, the DBA can be whatever you want. It doesn't have to have anything to do with your name. Keep in mind, and I'll say this as a disclaimer as well, this has nothing to do with trademark. Trademark is completely different, an area I happen to practice, but trademark is completely different. So don't assume that just because you can register Wet Socks with the state that you're covered by trademark. Different story altogether. We can talk about that anytime you'd like. Okay. Yes, Cody.
I actually have and in my business, but instead of A&D, I've used the ampersand before. And when I've entered that on particular forms, they said, no. We can't use that.
That's right.
And I say, no, because it's actually registered with the ampersand. That is the name of the business.
Okay.
Is there any sort of issues with essentially, let's say, marketing materials using A&D as opposed to the ampersand?
I don't think so, no. Again, it really comes down to, did you put somebody on notice that you're,
Gotcha.
If you use... I can't think of an example off the top of my head, but if you spell it wrong, so if it's, your Y-O-U-R is what you registered, and you put Y-O-U''RE for some reason in your materials, that might get a little sketchy, right? I would probably not recommend doing that.
So you write code also in your spare time, right? So in regards to Cody's question, could you escape that ampersand by putting a front slash in front of it?
Sure.
Because it's all going in as a PHP string, right? Would it be recognized?
Well, depending on what you're putting it on, sure, yeah. You could do character, changing the ASCII type or something like that, of course.
Right. So you can. Right, but you can spoof it by putting in either.
Well, it's more about SQL injection. SQL injection is why they don't allow that generally.
Pat, go ahead.
Hi.
Oh, I'm sorry. Could you just briefly touch on commingling of funds
in sole proprietorships?
I will, and can we talk about that in a little bit? Because
Sure.
that'll come up. Let's talk about that at the end, if that's okay.
Okay.
But yes, that's a very good point to talk about at the end.
Okay, because I had reasons for asking.
Just remind me, and if Don had his druthers, you'd put that on Slido. So.
Okay. See, I'm having trouble getting on Slido.
If you can't put it on Slido yourself, have your neighbor put it on there so we can get a record of it.
Hi, back to the fictitious name. If you operate as a sole proprietorship or a partnership, can you register a fictitious name, and who do you register that with?
Yes, you can register a fictitious name with the Secretary of State, regardless of what type of entity you are. And what they're going to ask you is, what's the name of your business, or who's running your business, or who's responsible for this DBA, right? So you would register it with the Secretary of State. They want to it's $70 in Pennsylvania. They want their $70 fee. And as long as there's no other company claiming rights to that name in Pennsylvania, you're good to go, right? Again, it's not a blessing to use it as a trademark. I'm just saying in Pennsylvania, all they care is there another entity trying to use that name?
Suppose you do business across state lines.
Yeah, don't, right.
So how many DBAs do you need?
You can't. Well, what would happen is if you're in Pennsylvania as your home base and you want to go into Jersey, what you need to do is you actually need to. So let's say you're an LLC in Pennsylvania and you want to file a DBA for your name as in Pennsylvania, and then you want to go into Jersey. You actually have to create a foreign entity in New Jersey, do the exact same procedure, where you would create your LLC, LLC, and then you would have to file a fictitious name in Jersey as well. Because it's very possible that Wet Sox is fine in Pennsylvania, but there's another company called Wet Sox in New Jersey who doesn't have a federal trademark.
So if you do business nationwide, let's say 50 states, and maybe in Romania or I'm just joking. So nationwide, you need 50 DBAs filing?
Well, 50 LLCs, yeah. If you're any state that you're in, you need a separate foreign entity LLC.
LLC or a DBA?
Well, it depends on what you're doing. If you're an LLC, you would have to file an LLC in that state. If you're a sole proprietorship and you're going into multiple states, number one, I think you're crazy. But number two, yes, you would need to file a DBA in that state.
Okay, I'm confused. An LLC in the other state or a DBA in the other state?
So let's back up a second. If you originally register as an LLC in Pennsylvania, right, you can take that LLC and go into any state that you want and register as a foreign entity, right? Generally, you'll do it as an LLC in there. If when in Pennsylvania you had a DBA for a particular name and you went into that other state and you wanted that same name over there, you would need to file a DBA also in that other state. If you went into 50 different states, you would need to file an LLC in each one of those states with the DBA.
Is that true for an Inc. or is that only true for an LLC?
No, in incorporated LLC, it's all based on the state that you're doing business out of.
Has this changed? Because I've done business literally all over the planet Earth.
Oh,
and
no,
I've never...
you can. No. Doing business in a state is different than having a presence in the state, right? So I sell X products, whatever the product is, and I want to sell it in Arizona. My home base is in Pennsylvania. I can sell it to Arizona, and there's no problem. I don't have to have an Arizona LLC or anything. But if I have a physical presence in Arizona and I'm operating out of there, I have to have a separate LLC for Arizona. You understand?
I guess there's a...
For services companies, do you have, like, I operate in 2 states?
So this question comes up a lot, okay? There's a right way and a sort of right way, okay?
Yeah.
The right way is if you cross state lines to do business, there's a very powerful argument that you are doing business in that state and you have a presence in that state because you're a service industry, right? You're not shipping product. You're not even delivering product. You're doing a service in that state. I, as an attorney, have to be barred in both New Jersey and Pennsylvania to do work in New Jersey. I have to be barred there too, right? Even though I'm a PA attorney. So I am an attorney in New Jersey. You would have to register your business with New Jersey as the proper way of doing it. You could get away with not doing it, but I would not recommend that. Okay, if you're going as a service business going into another state, I would recommend creating your business entity in that state.
Okay, thank you.
Sure. Yes.
That brings up yet another question.
Of course it does. That's why we're here. Free legal advice. All right,
correct.
good.
So here's the situation. So I'm PA-based. My company is PA-based.
Yes.
And I have no problems advising the millions of people around in the state of Pennsylvania.
Yep.
Because my physical presence is here.
Correct.
Now, I go to a networking event
Yes.
in New Jersey. Let's say I go to, Cherry Hill or something.
Sure.
And at a networking event, I meet somebody. Now, technically, that's business, even though I'm not physically present.
I wouldn't say so.
Okay.
I wouldn't say so. I would say if you go to New Jersey on a regular basis to set up shop over there or something like that, where you're advertising, come see me at my Jersey location or something like that,
Okay.
that would be setting up shop, right? That's a different story than just going into Jersey at a networking event. Yes, ma'am.
I'm still confused about the presence story because, like, for example, fictitious, let's say hypothetically,
Yes.
someone who is based in Pennsylvania were to lend money to buy a property that was in New Jersey.
Where's the transaction taking place?
The actual purchase would be taking place in Pennsylvania, but the property
The lending of the money, you mean, would take place in Pennsylvania,
and the
right?
closing on the project.
Would take place in Pennsylvania.
Right.
Sure. Okay.
But the property itself is in New Jersey.
Okay.
And so do you need...
So if you are...
Hypothetically.
My suggestion is, okay, and again, attorneys might differ on this point. If you're a business, a PA entity, whether you're a sole proprietor or whatever, and you're buying a property in New Jersey, if you're buying that property...
lending money to someone who's buying a property in New Jersey.
Well, if you're lending it to someone who's buying it in New Jersey, it doesn't matter. You're doing business in Pennsylvania. You don't. It's your concern is not where the money goes. Your concern as the lender is I'm doing business in PA, right? Even if you were to cross the state to sign the documents, that would probably be okay. Don't quote me on that, even though it's being recorded. But I would say you're probably okay. If you go over into Jersey and you set up shop there and start lending money, to Jersey, to people out of New Jersey, that would be a different story.
So the money lending actually takes place in Pennsylvania,
Right.
But the property's in New Jersey.
It doesn't matter where they purchased the property, in my opinion.
All right,
It would
thank
just be where they're actually doing the business with you at.
Thank you. Lynn?
Okay, we have not yet discussed 501c3 nonprofits. So we are in the greater Philadelphia area, which includes New Jersey, and I'd love to be in Delaware. So what happens if we have workshops that we monetize in other states, but we are registered Pennsylvania nonprofit corporation? Also, what happens if we do online business such as webinars and whatnot? How does that work?
Okay.
And that could be international.
When you say monetize, you mean like doing fundraising and other
Hypothetically.
No. Monetize as in we will charge to attend a workshop in New Jersey or charge to attend a workshop in
If you're charging
Delaware.
to attend a workshop in New Jersey, I see no reason why you wouldn't need to register as an LLC or a 501c3 in New Jersey, because that's where the transaction is taking place.
So in order to make maybe $80 or $100, I got to spend $600 to register as a corporation in New
And the
Jersey.
breaks, yeah. I mean, quite honestly, I would think so. In law, we have something called pro hoc vici, which allows me to go into another state for one time to do something. I'm not aware of something like that, and that doesn't mean it doesn't exist. It just means I don't know about it. I'm not aware of something like that for business entities, because at the end of the day, the government doesn't. While they care what you're doing, as long as it's lawful, they don't really care what you're doing as long as it's lawful, doesn't hurt people. It's about who do I sue, okay? And if you go into New Jersey and do business, and you're a PA LLC, well, the resident in New Jersey who was damaged from whatever you're doing doesn't know who to sue because there's no New Jersey entity. They thought they were working with a Jersey company, right? That's what it's about. It's about protecting the consumer or the purchaser of the product.
And what if you have webinars available on an online learning management system?
Online's
platform?
completely different. Online's entirely different. There's laws and everything associated with. They're changing, but there's laws and everything associated with it. It's if you are in a short way of saying it is, if you're targeting people specifically in a state, you probably are trying to do business in that state. If you just have an internet presence set up and people from New Jersey happen to come to your site or whatever, that's not targeting people in New Jersey.
Can I expand on that? So specifically, what it really boils down to, especially for New Jersey, would be, are they collecting your sales tax or anything else like that? So with your online presence, because you're, let's say, out of Philadelphia and you're in PA, when you have some sort of online presence, just like Amazon does, because Amazon doesn't have most of the physical locations in all 50 states, or they didn't used to, they would only collect the sales tax based out of where their actual physical location was shipping. So if they sold in New Jersey and their factory was in New Jersey or their warehouse, they would collect New Jersey sales tax.
We're tax exempt.
Exactly. So for you in particular, that applies if you're actually going to do business as in physical locations. So you might still have to apply. Like New Jersey has a charities registration, so you might have to apply for their charities registration as well.
Sure.
501c3 is a federal tax status. Okay, it is not a corporate status.
It's still a corporation,
if you're
right?
selling a product or service, New Jersey wants their state sales tax.
Yep. It's still a corporation. It's just, that's exactly
Still a
right. It's a tax status.
So in New Jersey, as a former state representative for a state or regulated industry, the deputy attorney generals were quite clear. If you are doing business with a New Jersey resident, a New Jersey business, you must be registered in that state. And to be registered in that state also requires that you have to register with the Department of Revenue within 60 days or there's a fine. Yep. So that they
NJ Reg
can,
73, I think it is, right?
Pardon me?
NJ Reg, REG?
I don't remember.
That's what it is. Yeah.
So if you have a house that's located in New Jersey, but I as the owner am in Pennsylvania and I'm borrowing money for you, we're doing business in Pennsylvania. But if I, as the owner of that property, am a resident of New Jersey, a New Jersey citizen, as far as they're concerned, you're doing business in New Jersey. I can't tell you where the law is on it.
Yeah,
I can only tell you it comes from the deputy attorney generals that I worked with.
And that's why I said, don't quote me on some of these things, because again, once you start crossing state lines, it gets really tricky. And I would say, sure, I need a few hours to research that to give you an absolute answer. That's why I said there's the right way, which I would always recommend exactly what he was saying, and then there's the it works way that I never recommend, but it works. All right, two more, I guess, and then we're going to move on because we have a lot more to get through.
I have a question about if you're hosting or you're sponsoring an event in New Jersey, so is it better to put it on Eventbrite so that it goes on there and you're not collecting the money? Do you know what I'm talking about? If you're hosting an event,
yeah,
and then you're charging for it, is it better to do it on Eventbrite?
You're hosting. You're a PA resident. And you're hosting an event in New Jersey where you're collecting money. Forget about where you're collecting it from. You're collecting money. I would say you're doing business in New Jersey.
Okay, but if you do it online, that's not considered to be.
I don't think it matters where you collect the money, because this is not shipping a product. This is getting people to go to a location, and that would be I would argue that it's doing business in that state.
So who would they be suing, the host or the company?
Whoever the person, everybody. I would say whoever the person thought they were doing business with.
Okay, so there would be the company and the host would be separate, the sponsor.
Possibly. It depends on it depends on how it's all set up. Okay. All right. And then one more.
I guess you can get sued anywhere, any place, doesn't matter. But my question is, I think what I hear is that when you say physical presence, you mean an address in another state. So it gets real complicated because, for instance, we're consultants. So sometimes we consult for clients in another state. We always get paid in Pennsylvania. Checks come to Pennsylvania. Yeah. Sometimes we sub to another consultant that's in another state, and we're all doing business someplace else around in the country. Yeah. So it gets complicated. I know that sometimes in some states they're so ridiculous you have to track for tax purposes because there's some tax because you physically were there, not on the phone. But so is that it? A physical address? I'm guessing. Well, we got to.
Well, based on what I'm sorry. What was your name, sir?
Yeah, New Jersey.
Gary. Based on what Gary said, and I tend to agree with what he said. If you're doing business with somebody in that, New Jersey has a lot of crazy laws when it comes to this stuff. Just so you're aware.
Stay out of New Jersey. Stay out of Jersey. I was going to say, stay out of Jersey.
If you're doing business in that with a resident of that state or a business in that state, they consider that doing business in the state. Even if, and according to Gary, and I would have to research this to verify, but I trust them. Even if it's being done in Pennsylvania, you're doing it with a resident of New Jersey. Apparently, New Jersey believes that's doing business in Jersey. I don't know the answer to that. I would have to research that before I can say conclusively.
Of course, every state's different.
Every state's different. Yes, every state's different. Okay, now, whew, that was a lot. All right, so that was the LLC. Now, fortunately, most of your questions will be answered with corporations as well, because it kind of follows the same suit. So starting up an LLC requires, again, registration with the Secretary of State, as well as an operating agreement if there are multiple members. Again, not a requirement for the operating agreement, but very, very highly recommended. You also need to register with your local township, as we said earlier, for tax purposes. All right, corporations. So similar first step. We get your EIN going, right? Employer identification number. Now, here you draft the articles of incorporations as well as the bylaws and initial share distributions. Difference between an LLC and a corporation for the purposes of the Secretary of State is the Secretary of State wants to know who has what share of the corporation. Okay, so you need to know initially this person has 40%, this person has 30%, this person has 30%. Okay, that's 100. Yes. So you need to know initially who has what shares of the corporation, how much ownership there is. You generally put that into your articles of incorporation, and you can even put that into your bylaws. The bylaws do not get registered, but the bylaws are held by the corporation so that if there's ever a question about how something operates and if someone is doing what's called their fiduciary duty, etc., it's all in the bylaws. Again, similar to an operating agreement, similar to a partnership agreement, but it's much more detailed. And then you file the articles of incorporation with the Secretary of State. And if applicable, again, register for a fictitious name. And there you go. Now you're in business. Okay. Once you get all those certificates back from the state, you're now in business. Okay. Again, there's tax implications. You know, you have to fill out certain forms every year. But for the most part, that's how you go about starting up your corporation. Okay. Now we're going to move on to liabilities, which really is probably why you're here tonight. Cody's so excited. All right. So liabilities. So who holds the liability of a business, right? That's probably what most of you want to know tonight. So if you're a sole proprietor, well, you do, okay? If you're a partnership, you and your partners, and we're going to talk about what's called joint and several liability. Big, big, big deal that most people don't realize what that actually means. And we'll talk about it in just a second. In an LLC, the LLC itself holds the liability, not the members. And a corporation, same thing. The corporation holds the liability, not the board and not the shareholders. Okay? So, well, that bottom line. Ignore that bottom line for now. All right, I need a volunteer, please. Audience participation. All right, stand up, please, once again.
She's worried about getting sued.
Assume you're a sole proprietor. Okay? Are you a sole proprietor? Oh, excellent. You're going to love this. All right. Now, assume that your company has $150,000 in available assets and $50,000 in outstanding debt. Okay? Now, assume that one of your employees, while on the job and under the name of your company, defames one of your customers. You know what defamation is? Okay. And assume that the customer sues your company and was awarded $500,000. I don't know what they said, but it must have been awful. All right? Now, and then assume that after you sold all of your company assets, you're still $400,000 in debt. Okay? How does the remaining $400,000 get satisfied? What do you think? No, you're a sole proprietor. How does it get satisfied? Well, it could very well come out of your personal assets, right? Your house, your car, your savings, your kids' college funds, right? Every personal asset that you have is within a creditor's reach. As a sole proprietor, if you are not an incorporated entity or an LLC or something like that, your personal assets are up for grabs. If for whatever reason you were to face some type of liability, such as being sued, you run up $200,000 in debt but can only pay $50,000 off, something like that, you know, slip and fall, whatever it's going to be, you can sit down. You're personally liable for the debts of the organization. Okay. That's a pretty big deal that most people don't realize is something that they probably should move on to something else like an LLC or a corporation. Yes.
Okay, so that's where insurance comes in.
Oh, we're not talking about insurance, but yes, insurance could come in, of course.
Well, that's okay. So
you have your general liability, your E&O insurance. Yeah, of course.
So some people would prefer to have less expenses for all this corporate structure stuff and just buy a good-sized insurance policy to cover all of these liability situations. Can you tell us if that's a good idea or a bad idea?
As Susan would say, it depends, right? So if you're just starting up and you want to go in business today and you're not doing very much, you may be doing $10,000 a year in business, yeah, you could probably get an insurance policy, but I'm going to tell you something. Your general liability insurance and your E&O insurance, which is errors and omission if you're not familiar with that, it's going to cost you more than to set up an LLC. You know how much an LLC costs in Pennsylvania without an attorney? $125. $125 to set up an LLC if you do it on your own. With an attorney, maybe $400 or $500, right? But $125 on your own to set up an LLC. You know what E&O insurance costs, right? A couple $1,000. Okay, so yes, you're right. You can buy that insurance policy and you can set up your own sole proprietorship and primarily protect yourself, but it's going to cost you significantly more.
Wouldn't you have insurance also if you had an LLC? You're not going to rely entirely
on... Yes, of course you would.
So insurance you're going to have it either way, right?
No, the difference is that with the LLC, you are protected with the LLC itself, right? So let's say your insurance lapses. Let's say your insurance is denying coverage. Let's say your insurance is saying, oh, no, that's not part of this policy because you didn't buy this particular waiver, right? What are you going to do then if you're a sole proprietor? Right?
Be more careful.
Be more careful, exactly. All right? So, a sole proprietorship offers nothing in the way of liability protection. Literally nothing. All right, now, I need 2 volunteers. Oh, fine, Cody, stand up. Who else? One more. Okay, please. Oh, Rhonda, there you go. Stand up. Okay, now, assume the 2 of you are partners. Okay, you're partners in a business. And assume, again, that your company has $150,000 in available assets with $50,000 in outstanding debt. And assume that an employee, again, while on the job, defames one of your customers, and they're awarded $500,000 for that defamation. Now, assume that if you sold all of your company assets again, you're still $400,000 in debt. Now you're partners. How does the $400,000 get satisfied? What do you think? Let's assume you're 50-50 partners. Okay. How does it get satisfied? Who owes what?
Both would be responsible for 50-50. Approximately 50-50. If it's
so $200,000 apiece? Okay. You're wrong. That is not the case. Okay. Let's assume Rhonda decided to leave the United States and she's off in Thailand somewhere. Okay. And she left no assets in the States.
I know a bad situation when I see one and I leave
too.
Yeah,
okay, exactly, yes. So as partners, all right, you are joint and severally liable, meaning that you're both liable for the full $400,000, not meaning that's a total of $800,000. It means that you're both liable for up to $400,000. So if both partners chipped in equally, right, you would both be on the hook for, say, $200,000. That's what you're thinking, right. But that's not correct, because if one of the partners isn't available, can't pay it, doesn't have the money, right, the other partner would be required to make up the shortfall. So one of you could be required to pay up to $400,000. One of you could pay $300,000 and $100,000 or whatever it is, okay? It has nothing to do with the 50-50 split of the partnership. You're joint and equally liable, joint and severally liable, okay? Just keep this in mind, that creditors will always go after the deepest pocket. Okay, so if one of you put in $500,000 into the business and the other one put in $10,000, but that, for whatever reason, the one with $10,000 has much deeper pockets and the one that has $500,000 is now bankrupt and has no money, they're going to go after the guy with that put in the $10,000, even though he only put in a small fraction of it. And he's just as liable as the other one.
So that's why you don't want your name on anything.
That's why what?
You don't want your name on anything, like your house.
Sure. Yeah, it's possible, yeah. Yes, if you don't have your name on your house, they wouldn't be able to go after it. But if you removed your name from the house after you found out you were being sued, that doesn't protect you.
And what about bank accounts?
Same thing. Same thing. If they can show that you did it to avoid the liability, they'll
No, before.
Oh, before. Well, if you don't have your name on a bank account, how are you getting money out?
If I had my name on a bank account with a partner, not this one, a different one, sorry. They would have to go after that one as well.
They could go after that as well, yeah.
That partner as well.
Well, only if it's a partner of the business.
No, if it wasn't a partner in the business, just money.
So forget about going after their bank account and talk about going after you individually. They could sue you individually. If they're awarded the judgment, then yes, any money that you have as assets could be sought in that judgment. All right, so a partnership offers nothing in the way of liability protection.
I think she's talking about her assets are combined with, let's say, her spouse.
Yes.
So that unless both the spouse and her were on this agreement, then they can't go after her alone. Is that basically?
I don't think that's the case. I don't believe that's right. It depends on the state. You're right. In Pennsylvania, it is it's tenancy by the entirety. So in Pennsylvania, that would be the case. In different states, that would not be the case. Some states have what is it? It's marital property and communal property, right? Those are the two types. So I think in a community property state, your assets could go after your individual assets, even if they're a joint account with your husband. In a marital property state, which Pennsylvania is, they would not. I don't believe they'd be able to do that. Again, that's something I would want to research before I give you a finite answer on.
Or put it under an LLC.
Or put it under an LLC, right. So again, a partnership offers nothing in the way of liability protection outside of the partners protecting each other. Keep in mind, you are fully responsible for the actions of your partner. That's not to say that you couldn't put something in the partnership agreement to protect yourself, but aside of something like that, you're fully responsible for the actions of your partner. All right. Now, LLCs. Again, 2 volunteers. Someone who hasn't stood up yet. Come on, it's fun. There he goes. There we go. Come on. There we go. All right, great. 2 guys. Great. All right. Now, assume, again, same type of thing, right?
Get closer to the mic, please.
Assume you are both members in the LLC or shareholders in a corporation, because it works the same. Again, $150,000 in assets, $50,000 in outstanding debt. Someone gets defamed, and there's a $500,000 award, right? Now, assume you sold all the assets, and you're still $400,000 in debt. How does the remaining $400,000 get satisfied? What do you think?
It would only be the asset. It would only be the assets that the LLC has.
And you sold them all off. There's still $400,000 in debt remaining. How does it get satisfied?
Chapter 11.
No idea? It doesn't.
Chapter 11. Bankruptcy.
It probably doesn't. No, you don't even have to file for bankruptcy. It probably doesn't. Okay? The LLC, you can sit down. Thank you. The LLC is a separate entity that now has 0 assets. There's no property, there's no bank accounts, there's no vehicles, there's nothing, right? You sold all the assets off and there's nothing left, and you're still owed $400,000, right? As long as you treated it like a business, and we'll talk about the commingling later on, as long as you treated it like a business, that debt probably doesn't get paid off by anybody in particular, because the LLC is now essentially has no money. You could say bankrupt, but bankruptcy is a legal term which requires a specific procedure. So without bankruptcy, you could still not be responsible for the money that you're owed. Now, that's not to say, hey, let's just start an LLC and start racking up debt, right? Because people have done that in the past, and there are plenty of cases where they have been shot in the foot for doing that, okay? You can't just start an LLC, go out, rack up tons of debt, and then say, I'm closing the doors and I'm not going to pay that debt off, right? They will see through that, the courts will see through that, and you will be personally responsible for it. You have to show that you've done things to treat the business like a business. You went out and got customers. You used your best business judgment in making certain purchases. You didn't have $20,000 in the bank and bought $1 million property somewhere, right? Things like that is what the courts are going to look at to determine if you actually treated your LLC or corporation like a separate entity, right? So as an incorporated entity, liability stops with the company itself. As long as you treat the business like a separate entity, and we'll talk about that right after this, you'll have no personal liability for the company's debts. Now, this doesn't include personal guarantees, right? So if you signed a bank loan for $50,000 for your business with a personal guarantee, that doesn't get wiped off, okay? But if you signed a copier lease for $15,000 for 5 years, or whatever it is, and the business goes either bankrupt or you shut the business down and there's no personal guarantee on it, No one's collecting on that copier. They can come get the copier, but they're not collecting on it. Yes?
So if you are a physician and you get together with other physicians and you form a partnership and you
Yes.
start providing services, in the medical field, you also should form an LLC?
Absolutely, yeah. I would absolutely recommend doing it because what happens is, again, you're forming a partnership. You are on the hook for any of the actions of your partners.
And then if you just make some extra money and you buy a house out of state and you start renting, do you still have to form an LLC if you are just like collecting rent from another state?
Yes, if you own property in a state and you're renting that property and collecting money, you are doing business in that state. Yes, you need to form your LLC. You need to, or I would do an LLC. You could do a sole proprietorship, but I wouldn't recommend it. Yes. Yes, you could do a trust as well. I am not getting into that.
Or both.
You can come up and talk about
Let's
that.
talk about trusts.
I might be getting ahead of myself here, but I've heard two different pieces of advice. One is that you form an LLC for each of your little, let's say you have 5 townhomes, you have one LLC for each.
That's
Other
a
people will say-
way to do it, yes.
Yeah. And the other piece of advice is, why do you want to mess with so many LLCs? You could have one and put 3 of them under it, and then another one for another 3. So is there a particular way?
I'll tell you why that's a bad idea. Would you like to explain why? Sure, go ahead. And Nate will tell you if you're right or wrong.
Come on, Larry, get to the mic, please.
Philadelphia is the perfect example of why never to do that. So if you sell a house in Philadelphia and you own 3 houses in your name, and one of those houses has a water bill that hasn't been paid by a tenant that the water company never told you about, and you sell this house, and this one has a water bill that's never been paid, you have to pay that water bill at this closing. Now, if you put them all in an LLC, same exact thing happens. What I do is I take my LLC and a trust for every single property. And the beneficiary of the trust is the LLC. I'm not giving legal advice, and I'm not an attorney. And I'm not an accountant. Check with your attorney and your accountant. And that's how so now this was an individual entity, this is an individual entity, this is an individual entity, and it's still one LLC. That's how I solve that problem.
Yep. That's another way to do it. Again, another way, as I said earlier, is each property is its own LLC too. You could do that. It can be. It certainly can be. Sure. There's multiple ways to skin the cat, right? The trust idea, it's a great idea. I'm not getting into trusts, obviously, but. Oh yeah, absolutely. Yep, and it's a pain in the neck. It's a pain in the neck. But the difference is, you might have an LLC for this property as a single member, partners over here, so you have a different LLC for that property because there's multiple members in that. So it depends on how you're doing it. Yes, Gary, please.
Gary, please come to the microphone.
And the reason for the microphone isn't so much that we can't hear you, well, that's part of it. Also, we want the recording to hear you.
So I want to come back to when you described the LLC being sued, and the judgment was $400,000. You only have $100,000 in the LLC.
Yes.
That takes $100,000. There are 0 assets now in that LLC. Would your advice be then to close off that LLC?
I will not answer that question. No, that's a trap. You're trapping me, Gary.
I wouldn't dare.
Theoretically, there's 2 ways to do it. Number 1 is to file for bankruptcy, right? That's probably the cleanest way to do it. Number 2 is this is not legal advice. Don't follow this advice. Yes, please, go ahead.
Wait. With the microphone, Larry, you know the rules.
Okay, stop. The answer is?
It depends.
Stop. Shut down. Just stop doing any business in the LLC. Take your checkbooks, rip it up, let it go, and create another LLC and start all over again. And just don't screw that one up.
There's one more step with that. You have to file an out of existence as well.
Yeah.
You'd want to file an out of existence so you're not attached to that LLC any longer.
What my lawyer would tell me to do.
Yes.
So assuming the LLC is left open,
yes,
and that judgment is out there against the LLC, something happens down the road for some reason, that LLC inherits some money somehow. where you inherit some money, somehow the poor corporate veil gets pierced, that the person has the judgment could come back after you. But if you close it down, then it completely, like Larry said, closes it all off.
The problem with closing the LLC is you have to file for tax certificate clearance from the state.
Yes.
And if you have a judgment against you, you're not going to get it. Right? So if you can't get your tax clearance certificate, you can't close it down officially. So, right?
Yeah.
My lawyer, which you may become very soon, because I'm very impressed with tonight, by the way. Because somebody needs protection from my
Because
brain.
his other lawyer's suing him.
That's for non-payment. Shh, don't tell him about that one. No, but again, I have noticed I've noticed that if I just stop using the LLC, stop filing, the IRS stops bothering me at one point, and that's kind of what I've done in the past. My name is Smith, John Smith.
Okay, so let's assume that's what he does.
Please edit this video.
No. And let's say that he goes to that other real estate workshop in the sky,
Yes.
right? And his estate now has to deal with all of this. What happens then to that LLC if there's still a liability
I am not
against
qualified to give estate information. I'm not an estate attorney. I don't want to give out that type of information.
Do you want to answer that, Larry? Come to the microphone. Come on. So the scenario is, yeah, we'll get you a lot.
Get a lapel. You really want to get me in trouble, don't you?
Yes, I do.
What was your name?
George.
Hemsley.
Yeah.
Fiona Hemsley,
So let's
right?
say you go to that great real estate workshop in the sky, right? Because your wife decides to do that to you, and your estate now has to deal with this LLC that has this liability against it. What happens? I know you don't care because you're somewhere else, but what does your wife have to
Really,
do?
but if it's an LLC, if it's a sole member LLC, I'm the member. It's done. It's over. There's nothing more to do.
What happens?
Does it get transferred into the
what
estate?
happens is if you file the out of existence, if you're a single member of an LLC and you file an out of existence of that LLC, it is now a shell company. There's nothing there. No one owns it. No one controls it. It's just literally a piece.
Well, let's say he
that exists on paper. Only.
Let's say he doesn't file that. He just goes to the bad place.
Oh,
if anybody
sure.
knows the TV show, not the
Go to
good
the good
place.
place,
You went
sorry.
the good place. Okay.
I got my ticket.
What state did you buy? Never mind. What happened? How does the estate deal with an LLC that has a liability?
Again, I can't give estate advice, but I will say the basic information that I know about that, again, without researching it, not legal advice, is if it isn't planned for in the operating agreement or some type of trust or something like that, that the assets would be transferred down to your heirs.
Not the assets, the liabilities.
What's that?
Not
Well,
the assets,
in this
the
case, it's the liabilities, but I'm saying if there's nothing in place that says what happens to an LLC and the sole member of the LLC passes away, I believe if there's no transfer, if there's no documentation on what happens in the event of death, I think it just shuts down. Nate, do you know the answer to that? I don't remember what happens. Oh yes, please.
That doesn't sound right.
We are way off topic here, just so you know. I just want to throw.
Welcome
throw
to the
that out there,
Consortium.
Mike. You really should have done
Once
the
he
questions
stands
at
me
the
up,
end.
it always happens.
My understanding is it goes in the order. There's different priority orders for the creditors. Again, I'm not an estate guy either. I do the same stuff that Mike does. But my understanding is that you look at the operating agreement. If there's one person and there's still assets and things to be sold, that there is each state has different orders of priority for all different liens and creditors and liabilities.
So could you have a
But if
standard
there's
clause?
No assets, my understanding is there's nothing there.
Can you have a standard clause in the LLC operating agreement, even if it's a single person, that just says, in the event of my demise or whatever, it's dissolved, it's over, it's gone? Can you just say that?
You don't want to do that.
Again, I want to say that's the default rule, but I'm not positive. I believe that's the default rule because what else could you possibly do? You can't transfer a business to your heirs unless you specifically say that I'm going to transfer it to my heirs, right? It doesn't just go to them. The assets of it would, but not the business itself. So in a sole proprietorship, for example, when the owner of the sole proprietor dies,
true, but if my heirs, okay, there's legality and there's reality, okay, and I live in the world of reality, and I love arguing with attorneys, reality versus legality.
Sure.
And I'm sorry, I'm not really arguing with you.
No, by all means.
But reality is if it's a money-making LLC, my wife is going to say, hire you, and she's going to say, make this continue to work.
Sure.
If she sees one that's in debt for $100,000 and there's no money making, she's going to go,
get this as far away from
Larry who?
Really? I didn't know he had that one.
Right.
No,
So-
he didn't have that one. No.
To summarize, I'm not sure. I really
That's
don't.
reality.
I would want to research that before.
Gary,
giving a more
you're going to
definite
answer this?
You're getting into creditor rights. Remember, the single member LLC is, from a tax standpoint, it's completely pass through. It's going to pass into the estate now, and now the estate has a legal obligation, and creditors have a legal responsibility to collect, the money that's due them. So you're really getting into creditors' rights more so that you can clear out the estate. And I haven't dealt with creditor rights in too long to really tell you anything more than that.
Thank you.
Okay, let's not go any further with that because I don't know the right answers to it. Some things I agree with, some things I don't. But again, that's without researching. So lawyers. Let's move on. All right, so let's talk about the corporate veil, or as Nate likes to call it, the corporate whale. Okay. All right. So what is the corporate veil? So there's this concept in law known as piercing the corporate veil. And what it basically means is that if you're an LLC or a corporation or some type of limited liability entity, you're protected should the business go out of business, have all these debts. You don't have to pay for them personally. However, there are things you can do to really screw yourself up and allow a creditor to pierce that veil of liability protection. So let's say you're an incorporated entity. So you have an LLC incorporation or non-incorporated entities, sole proprietorship, and general partnership. Okay? There's this line between you called the corporate veil. Okay? So what it means is that, is there a pointer on this?
Please press the big button.
Nice, there we go. All right, so for those of you who can see it, so if you're on this side of the wall, an angry creditor can't get through and get over to you. He's blocked by this wall. If you're on this side of the wall, the angry creditor can go right to you and collect money, okay? Over here, they can't collect money. What is it? Why does it exist? What's the purpose of it? All right, well, the corporate veil is the liability protection that you're guaranteed by the entity type that you've chosen, the LLC, corporation, whatever. But there are ways to get around that. So earlier, what was your name? I'm sorry. Pat? Okay, Pat had asked a question about commingling funds. One of the easiest ways to pierce the corporate veil is to commingle funds, okay? So if you're an LLC, your LLC has its own tax ID number. We went over this. It's going to have its own bank account. It's its own separate entity. And then there's you over here who happens to run the LLC, who happens to get paid by the LLC, who handles all the books for the LLC. Well, if you start treating the bank account of the LLC as your own personal piggy bank, right? You go in, take money whenever you want, right? Not as a draw, you just take money out. You use the company credit card to pay for dinner with the family or go to the movies or something like that. You know that you owe $50,000 to your vendor and there's $50,000 in the account, but you decide to take 20 out for yourself. That's commingling funds, okay? And that's the surest way to pierce the veil, all right? So if you are an LLC and you get sued, normally you're protected by that liability. But if the other side could show that you were doing things or you didn't treat the business like a business, such as commingling funds, they can get through that veil. And the reason is because, as we said earlier, the courts and the government don't want people setting up LLCs, racking up huge debts, and then taking a hike, right? Because what's that do? That leaves the vendors in bad shape, the creditors in bad shape. So that veil is there to protect you, but it's only there as long as you're treating it like a business. So what are some other things that you can do to, oh, please. I wasn't asking for suggestions, but by all means.
So I have a question.
Yes.
And when you're a corporation incorporated and you are also studying and require education for yourself for running the business,
Yeah.
will that be calling the corporate or piercing the corporate veil, or how does it go?
What do you mean by that? I'm sorry. So you're...
For education purposes, you would need to register online for online courses and stuff like that.
Okay. This is more tax questions.
Okay.
I'll answer it a little bit, but I'm not going to go into detail because I don't know the full answer. But if you're doing something for the benefit of the company, right, then you're using what's called the business judgment rule. Well, the business judgment rule comes into play where you're using your best business judgment. And as long as you can show that it was for the benefit of the company, you're generally going to be okay. If you are running a dry cleaning service and you decide to start taking classes on car repairs, right? Probably not for the benefit of the company. Right? So that's when the commingling would probably come into play.
Okay, awesome.
Does that make sense?
Yes.
Okay. Sir.
Wet socks.
Wet socks.
Wet Socks LLC.
Thank God I didn't. Anyway. So I'm incorporated under the name Pigart Graphics.
Okay.
And everything gets deposited into a checking account for that.
Yes.
Now, sometimes people write Pigart on the checks. Does that mean I should do a DBA? Because I don't necessarily control what somebody writes.
No, so my law practice is Terkanian Law LLC. I get people writing me checks all the time to Michael Terkanian, right?
Okay.
Feel free, any one of you, by the way. But I get people all the time. I deposit it in my business account because it's a business check. It's for business services. Where I might get in trouble is if I were to take that check and deposit it in my personal account, right? Because my client thought it was a business going to my business account, right? Mm-hmm. Even though they wrote my name on it, I could see an argument for, well, you cashed that check under your personal, and now I'm suing you for some unrelated thing. I'm going to show that as commingling funds.
Okay, yeah, everything is always deposited into
you're
the
fine.
business.
You're fine. They might put the wrong name on there or something like that's close enough. The banks, what you're asking about is whether there's two parts to it, right? So there's the commingling, and then is the bank going to take the check? The bank only cares that the person's not going to come back and say, oh, no, I didn't write that check to them, right? Mm-hmm. So put that part aside. The other side is, where did the money go? It went to the business account.
Okay.
So you're generally okay with that.
Okay.
Does he put deposit only on the back, or doesn't that matter?
I do. I always do. I write deposit only in the back of my checks. Hold on. There's one over here.
I was going to say, or just have them always write them to cash. Always.
Yeah, of course. Sure.
We'll take that off the recording.
So I have a quick question.
Sure.
I'm a single member LLC.
None of your questions are quick, by the way.
Well, I'll make this one short then. Is the official title member? I understand member. Could you call yourself anything when you sign an agreement? Does it always have to say member?
That is a fantastic question. Lawyers will disagree on this. I think Nate and I might disagree on this. I'm not sure. I always recommend to my clients, anything you can do to make yourself stand out as running the business as opposed to commingling funds and things like that, you do. Hence the single member operating agreement. Absolutely not necessary for legal purposes, but it's another way to show that you're doing things with the entity as the business as a separate entity. Calling yourself a member is the right move because you do not own an LLC. You do not own a corporation. You are a member of an LLC. You are a shareholder of a corporation, okay? And when you go and you sign a piece of paper with the name of your company on it and it says owner, I tell my clients every time, have them redraft it and put member on there because you are the member, maybe the managing member, right? Maybe the sole member, but you're the member of an LLC because that is a legal designation according to the state, okay? So I never recommend, I'm not saying that it's wrong to do owner, but it's just another thing that could go wrong down the line, I think. Oh, no, president's, that's different. President is your title within the company. That's different. Yes.
Don't worry. I'm going to add to that.
Yeah, sure.
Something that I learned a long time ago, and it's worked because I needed it. I never signed anything Larry Steinhaus member. I signed for blah, blah,
Yes.
blah, LLC, Larry Steinhaus member, not a personal guarantee.
There you go. Authorized agent or something like that. Yeah.
And I literally put that in, and the judge said, look, it's not a personal guarantee.
Yep.
Any discussion?
Yeah. No, it's a very valid point. Sir.
I think I know the answer to this, but it's
good.
worth
Thank you.
worth having the attorneys weigh in on this. So, as is true for most business owners, there are times when the business runs into a cash crunch.
Sure.
So you personally lend money, say $5,000 to clear payroll in a particular period.
Yes.
Now, in the way my accounting is set up, I put it like transfer funds, and my accounts are linked.
Yeah.
But I keep separate account books for all of these things. So I put $5,000 there.
It's a reimbursable expense, sure.
Yeah, and then 2 weeks later, I return the $5,000 back, and even if I add interest to myself, that's okay.
Nothing wrong with that. Okay, there's nothing wrong with that at all. So with interest, hold off on the interest. There's still nothing wrong with it. We'll talk about that in a second. The first part of it is very simple. There's a money trail.
Yep.
It went in, it went out, as opposed to coming from your clients or your customers and going out without any recording of that, right? The interest part is very easy. Do you have an agreement with your company? Okay, as long as you have an interest-bearing agreement that says, I'm going to be entitled to 6% interest on this for whatever, APR, whatever it's going to be, then you're perfectly fine. Even if you didn't have it, you probably would be okay as long as it's reasonable, like not 80% interest, right? Because usury laws come into play. But if you have a general 6% or whatever the number is going to be, as long as it's reasonable, you're perfectly fine. Nothing wrong with that. No, it could be zero. Yeah, you don't have to. You don't have to charge your company doesn't have to. You don't have to charge your company interest. I don't see why you wouldn't, but you don't have to, right? The only thing is now you have to record that interest at the end of the year with your accountant. But another story another time. All right, moving on. 8:15. Jeez. Okay, now we'll talk about tax implications. All right. So disclaimer number 2: I am not a tax attorney, and I am not qualified to give individual tax advice. Okay. I cannot answer individual questions about tax issues, concerns, planning, or anything of the sort. The following information is of a general nature and may not reflect the most current legal developments, although I think they do, but again, they might not. I make no warranties or guarantees about any of the following information. Should you have specific questions about your individual tax concerns, please speak with your accountant. All right, so taxes from profits. As a sole proprietor, it gets added to your personal income. So if you make $100,000 in profits, your personal income goes up $100,000. Partnership, similar. It gets added to your personal income based on your partnership agreement. So your partnership agreement might say 70-30. So one partner gets 70% of the profits, the other one gets 30% of the profits, right? $100,000, 70 to one's bottom line, 30 to the other bottom line. Depends on how you have it set up. LLC, pass-through taxation. Again, it gets added to your personal income. So if you make $100,000 as part of your LLC, you're going to get a Schedule K1, right? Yes. Schedule K1, and that gets added to your personal income tax. And then corporation. Corporate tax. Corporation is taxed independently, and then the dividends are also taxed. This is what's known as double taxation. I am not getting into a tax class here because I'm not qualified to do it. However, just so you're aware. All right, so sole proprietorship. So assume you paid yourself $75,000 for your services to the business, and assume that the business made an additional $125,000 in profits. Okay, you personally would be responsible for your $75,000 that you were paid and this $125,000 in profits for a total of $200,000. That's your IRS, state, local, Medicare, Social Security, unemployment. All these taxes you would have to pay as a sole proprietor. Okay, partnerships. Generally, the partnership agreement will lay out how much each business partner will own of the company or how much of the profits they'll own. So again, assume $75,000 was paid to you for your services. Your partnership made an additional $300,000 in profits, and you're a one-third owner. So that's another $100,000 that you would have in ownership. So you would pay income tax on $175,000, right? Again, IRS, state, local, Medicare, Social Security, unemployment. FICA. We all love FICA. Okay. Now, LLC, without a Chapter S, Subchapter S election, generally the operating agreement, similar to a partnership, will lay out how much each member of the business owns. Okay. So again, 75 in services, 300,000 in profits. You own 1/3. Same thing. 175,000 to your bottom line that you have to pay income tax on. We're not going to get into, when the LLC gives the members' tax, money for taxes and things like that. We're not getting into any of that. This is just, again, general information. All right, now, corporation or LLC subchapter S, okay, which is a thing. So assume you're paid $75,000 from your entity for your services. Your business made $300,000. You own 1/3 of the outstanding shares, and that the company distributed $100,000 to you in distributions, okay, or dividends, depending on which entity you are. This is not income as far as personal income tax. This is dividends, okay? It's taxed differently. So the $75,000 that you earned is taxed as income. IRS, state, local, Medicare, Social Security, unemployment. The $100,000 distribution is taxed at capital gains, okay, which right now I believe could be up to 23.8% depending on your tax bracket. But if you're getting
15 though.
What's that? No, it's not. It depends on your tax bracket. So it goes 0, 10, 15, 20 with a 3.8 kicker at the end, right? So it all depends on how much you earn in your tax bracket. And that's still, even with the new plan, that's still currently how it works. Although they're talking about restructuring that at some point, who knows? Now, the new tax law may allow you as a business owner to deduct 20% of your earnings, okay, which are really complicated rules, and I couldn't even, I was reading them, it's like, this makes no sense to me. So talk to your accountant if you're curious about that. But if you are a business owner and you distribute, not earn, but distribute money to yourself as a dividend or something like that, you can actually deduct up to 20% of that off of your income tax. Again, talk to your accountant about that, but that is a really cool new feature if you know how to take advantage of it.
Are you going to cover pass-through income?
I did.
Oh,
I did that,
okay.
right? I wasn't crazy? Okay,
Sorry,
yeah.
I didn't hear you use the word pass-through. That's
I didn't say pass-through.
my mistake.
I used the word pass-through? Oh, I'm sorry. Yeah, that was your LLC is your pass-through. LLC without the S. Now, corporation without a subchapter S election, it's a little bit different, but not much. Again, $75,000 in services, $300,000 in profits. You own 1/3 of the outstanding shares. You get $100,000 in dividends. The $75,000 that you earn in services are taxed at the standard income tax rates. And then the corporation, now this is where the double taxation comes into play. The corporation would be taxed at a rate now it was 35, now it's 21% of the $300,000. And then any dividends, let's say $100,000 was distributed to you, you would be taxed at the capital gains rate of 23.8%, depending on your tax bracket, okay? That's basically that's when they talk about the double taxation. It's the corporation paying the corporate rate and then the shareholder paying the dividend rate, okay? Again, not a tax attorney, very basic information. Please speak with an accountant if you have deeper questions about this type of stuff. All right, and last but not least, what do I recommend? When my clients come to me, again, it depends on the circumstances, what they're trying to do, et cetera, but generally I would say 95% of the time, I recommend a LLC subchapter S election for my clients. And the reason is because you can earn up, this is new in the tax rules now, if you earn up to $157,500 individually or $315 filing jointfully, and it's a qualified business income, don't ask what qualified means, because no one knows. It could come into play and give you a much better tax advantage. Again, talk to your accountant first. The way it used to work, and I think it still works like this, but the rules are a little convoluted, is if so let's say your business makes $100,000, and you're just a regular old LLC, pass through to you $100,000, you're paying income tax on $100,000, right? That's Social Security, Medicare, all those fun things. If you're an LLC type S, and you can show that your services to the company were only worth $70,000, you can pay yourself $70,000, and the income tax is on $70,000, and then the other $30,000 could be sent to you as a distribution, because now you're a type S, which allows you to distribute money almost similar to dividends. And now you're paying the capital gains tax on it as opposed to the income tax, which should be a significant savings depending on your tax bracket. It still works like that to a point. I believe it may even work exactly the same way. But again, the new tax rules are very, very convoluted, and not everybody has figured it out. So don't hold me to that. But that was one of the advantages of electing a type S or subchapter S. So keep in mind something about LLCs. As I said, setting it up is actually pretty easy. Even if you're already an LLC, it's real easy to take advantage of the S election. It's filling out a single form with the IRS, and it's free. You could do it on your own. It's not terribly difficult. Of course, you're welcome to call an attorney to do it as well. So obviously we're here to help. So with that, ladies and gentlemen, third disclaimer. While I'm happy to answer any of your questions in the forthcoming Q&A, please note two very important rules. Any answers given do not create an attorney-client relationship. Yes, I have to keep saying that because there have been issues where an attorney at a meeting would just go up and someone would ask them a question. Yeah, sure, this is what you do. And next thing you know, that person thinks it's their attorney, and now they're trying to take them into the courtroom to argue for them, and it causes all kinds of problems. So there will be no attorney-client relationships created tonight unless we fill out documents, et cetera, et cetera. And I am not qualified to answer questions in tax matters. I will give you general answers to the best of my knowledge, but any answers given should not be considered tax advice. And with that, I open it up to Q&A, and I invite Nathan to come up, and he can help me answer some of these questions as well.
I think he's going to leave the room now. Okay, let me get the Slido up just in case. Okay. But if anybody has any questions, please come to the microphone.
Yeah, sure.
We got really caught up on the operating agreements. Personally, I know Mike, and I agree with you completely, that they're not always necessary. You really should do it. I mean, all of these things we talked about other names that your business is doing business under, that can be in there. You're going to avoid a lot of problems with the people that you're doing business with, too. If we had this situation where you two formed a partnership in this meeting, if you left the room and that was your partnership, I wouldn't want to be in that partnership. I want a paper that has every possibility of what could happen. This man talked about being able to find a form agreement for an operating partnership. Lots of people do that. I wouldn't do it, not just because I'm a lawyer, but because there's going to be things in there that you may not think of. Say, for example, voting rights. You could have voting rights in this partnership. There's all sorts of different partnerships. You could have 3 people. You could have 20 people. So the different voting rights on how you make decisions can be affected by the number of people that are in it. You may have all sorts of clauses that have to do with where you're going to have like an arbitration or a mediation. You don't want to find out that you put a mistake in a document that was a form agreement when you really could have made it specific to you and your own problems. It's not so much a pitch, it's just, I would say that that's something that you should absolutely consider. A lot of this, we really got off track a lot on the real estate stuff. I was surprised that how many people apparently want to have real estate in all these different states. I think the purpose of this was mainly to talk about different types of business organizations, and that can apply to real estate. But just like in real estate, or whether you're selling the Doylestown man selling the wet socks, it's a niche market in Doylestown, I suppose. Real estate is one entity or one area that has all sorts of intricacies. And there are reasons why you would want to incorporate in certain instances, and other instances where you may just want to fall back on insurance. But mainly, if you're thinking about going into business alone, or whether you're thinking about doing business with other people, you want to make sure all your I's are dotted and your T's are crossed, and to have a good operating agreement before you have everything official is very important. Just having a name isn't going to do much for you. So that's all I wanted to say based on what I heard in the questions and the answers today.
All right. So, questions, please.
So I am a real estate advisor and coach with mostly new people, and they quite often come to me. They already have their LLCs formed, and I say, for what reason? And they don't really know why to begin with. And then when I start to explore some things with them, I said, your LLC really isn't doing anything for you. They're not having, these are all, I think in almost every case, a single member. They're not having annual meetings. They're signing their names to the check personally. They don't have a clue, and this is something I would like for you to address, is you have a spouse with a single member LLC, what does that mean? Okay. And the third thing that they're typically not doing is let's say they go out to open up a checking account or to borrow money because they need it for payroll. There's no documentation that and this throws everybody off because they're a single member. How am I supposed to sign a loan form with myself? Or do I have an annual meeting with myself? So I was wondering if there are any other scenarios that come to mind of piercing the corporate veil. The things that people are just commonly doing, not realizing that the combination of all these things basically completely do away with that corporate veil and the asset protection they're looking for.
You covered a lot of them. I mean, well, seriously, you did, right? Writing the checks out to yourselves or having your own names on the checks. Yeah, that's one thing that could be that could lead to it. It's really, there are certain rules and certain steps that a court will follow, and unfortunately I don't have them with me. I probably should have written them down, but again, I don't want to give legal advice here. There are certain rules that courts will follow to see if you're piercing the corporate veil. Some of the things like the operating agreement and doing the DBA and things like that, not that much DBA, but other things, is it's just another layer of protection to, if you're ever in front of a judge and the judge says, well, what have you done to treat this differently, or how have you treated it as a separate entity? Anything you can say, well, Your Honor, it has its own checkbook, it has its own accounting, it has its own, I had the operating agreement for it, I do hold an annual meeting, even if it's with yourself, to just say that there's no changes, right? Which is a thing. It is a thing. So anything that you can do to show and record that you've treated the business as a separate entity helps. I'm sure I'm on the spot here. I'm not really thinking about what other, because you mentioned most of them, what other things could a court look at to say, no, you didn't treat it as a separate entity. I mean, the commingling of the funds is the biggest one that most people fall victim to. Something else, okay, so I mentioned earlier about the business judgment rule. Okay, so when you're running an organization and you're doing something for the benefit of the organization, okay, so let's say that there's a new investment opportunity, and you're the president of a company or you run the board of directors, whatever, and your judgment tells you that this is good for the business, and you invest and lose everything, okay? And now the shareholders want to sue you, right? Let's say you have, if you're an LLC, let's say you have people who have given you money as an investment, and now they lost all their money as well. As long as you did your actions as part of the best judgment for the business, and you can show why you think it was the best judgment, business judgment rule comes into play and you're protected. But let's say you did it because you actually own the thing that it was going to be invested in, right? So the business is going to invest in X and you own X, and it was for your personal benefit. Maybe it was also for the benefit of the business, but primarily it was for your personal benefit. You would probably lose that argument because you did something that wasn't in the best interest of the business. As a business owner, you have, as a member of an LLC or the shareholder or board member of a corporation, you have a fiduciary duty to that entity. And the fiduciary duty means that you need to do what's in the best interest of the entity, not necessarily yourself. So, for example, if some situation occurs where if the company buys a property, I'm just making this up, a company buys a property and it will benefit the company but hurt you individually, you must do what's best for the company, okay? You can't hold back on the purchase of a piece of property because you want to buy it personally, okay? If somehow that came about and shareholders lost money and it could be proven that you did it for personal gain, you violated your fiduciary duty. And that's where Act 170 comes into play, that you violated your fiduciary duty to the business, and now you can be sued for it. Is that a little more insight? Okay. So again, there's a lot of things that that could pierce the corporate veil, but it's again, it is fact intensive, and you have to be able to prove. You can't just say that it happened. You have to be able to prove that it happened with malicious intent. The spouses, okay. Trying to think if I want to, because this starts getting more into legal advice than anything else. But I'll tell you what I recommend, what I tell my clients to do. When my clients, most are married and have a spouse or whatever, even kids, and they are members of a multi-member LLC, what we recommend that they do is they buy a life insurance policy for the member, right? So I would buy. So if Nate and I are partners in an LLC or members in an LLC, and I'm married, I would want the business to buy a life insurance policy for me that we agree in the operating agreement. If I were to die, the life insurance policy would be paid to the LLC, who would then purchase my assets of the LLC from my spouse. What's that? Yes, correct. That's how I would do it. That's what I recommend to my clients in many situations. I don't know if that directly answers your question, but I don't want to go too much deeper than that. Well, we talked about that earlier, and I don't want to answer that question without more research. I don't remember it off the top of my head. There is a rule that applies, but I have not dealt with that in a very, very long time, probably since law school, actually. So I don't know off the top of my head. Yeah, microphone, come on.
Are there any other lawyers in the room? Yeah, cool. You a lawyer? No. Put your hands over your ears, please.
He plays one on TV.
Put your hands over your ears, please. Okay. So you guys are all overwhelmed. You all have these LLCs for the last 5 years ago. Oh my God, I didn't do annual minutes. Oh my God, I didn't do operating agreement. Oh my God, oh my God, oh my God. There's something called discovery. Gives you a lot of time to solve these problems. Everybody reading between the lines? So don't panic. Just do what you need to do. You get it?
All right, so Slido. So the first question here, differences between multi-member LLC and partnership. Nate, you want to take this one?
Well, again, have an operating agreement, so that's a similarity. But difference is you have the pass-through taxation. In the LLC, you also have the joint and several liability in the partnership. And the example that was used is, if two people are in a partnership and there was $400,000 that was owed, would it be split equally? No, because if the other person doesn't have it, you're still on the hook for it. I had another one at the tip of my tongue here, Mike. Filing. The partnership, you do not have to file. LLCs, you would file it with the state. What am I missing here, Mike?
Registration. Oh, well, file. Okay, you were
Filing,
filing
yeah.
the registration. Also with taxes as well. Partnerships is a separate. It's different. So partnerships is a different type of tax filing than is a multi-member LLC or an LLC in general. So, and lastly is no, they're both okay. A single member LLC is what's known as a disregarded entity according to the IRS, as is a partnership. No, that's not true. No, sole proprietor is. So no, a partnership and a multi-member LLC are both recognized as partnerships according to the IRS. So, okay, scratch that entire last 30 seconds. Doesn't apply. All right, so no, I think that pretty much covers it. I think we're good there. Yeah. All right, what trusts for operating a business? I don't know what that question is asking.
Who asked that question? Are they in the room?
Real quick, on the partnership and the LLCs, just real quick. Another key reason why you need that operating agreement, you have a board of directors usually, but there are partnerships that want to be manager-driven as opposed to a board of managers, and that can also be a difference in how each of them are run. I'm sorry, I think you were saying something.
Well, and I guess, Gary, you raised your hand. You want to clarify that question, Gary?
I was asking the question relative to a trust that has an LLC in it, if there anything that you want to comment on that.
I'm going to be honest, I have not done anything with trusts in any of this work. I don't believe that Mike has either. If you trust.
I was asked if, just any comments on what a trust, owns an LLC.
Is it that way or the other way around?
It could be both. That's the point. That's
Yeah,
exactly,
yeah.
that's what I was going to say. It could be both.
Tell them that, because I
I'm
don't.
going to, but okay. What do you want me to do? I got the camera over there. I'm talking to you. I'm talking to him. Okay. Yeah, it could be either way. So you can have, for example, you can have a trust. You have the beneficiaries of a trust being two LLCs. You can have I don't think you can have a trustee being an LLC. That wouldn't make any sense. But you can have okay. So you have right. You can have the LLC could be a trustee. Could be a trustee. Okay. Yeah, there's the answer. Yeah, there's the answer. Okay. So so it can go either way. It can go either way. You get it?
Larry, what's your disclaimer? You have to give us a disclaimer here.
My mother wanted me to be an attorney, but I couldn't take the pay cut.
All right. Comment on Series LLC. No, please go ahead.
Again, this is a question I have had both. I still do own both. Between an LLC with subchapter S election versus a corporation with a subchapter S collect. I favored the corporation with a subchapter because one time I incorporated in Delaware as an LLC, and then you had to pay Delaware annual agent fees and all this other stuff. So I bailed out of that. Now I only have S chapter corporation here in Pennsylvania.
Yes.
But it so happened that my daughter started another company, and the lawyers up in New York set it up as an LLC registered in Delaware. So it's a accounting thing, but I just want to know for the clarity from a legal operating entity.
So is your question
preference? Which one would be more preferable? What would be the pros and cons of one versus the other?
So, in reality, as far as I am aware and what I'm thinking right now, the operational structure of a corp, C corp subchapter S, LLC subchapter S has to do with formation and annual requirements. The formation is more difficult with a C corp, right? Forget about the subchapter S election; it's more difficult. There's requirements for the board of directors. Some states require specific. You have to have a certain number of directors, right? Yeah, exactly. You have to have generally at least 2 or 3. You have to have an annual meeting where you just, even if it's, we meetings to order, meetings adjourned. You have to do something that has to be recorded. Have to have a secretary recording it. All that stuff is something you would have to do as part of a C corp. LLCs don't have nearly as many of those issues, right? You're supposed to have an annual meeting, but in reality, it's not so much for the outside people looking in as it is for the members themselves, right? So the members want to get together and have an annual meeting to discuss the valuation of the business and things like that, which could come into play down the line. And again, the actual registration of the LLC is 2 pages, right? It's the LLC registration and the docking statement. And that's it. The corporation, you need the articles of incorporation. There's a couple of forms you have to fill out, et cetera. So it becomes more complicated. But as far as once it's set up, other than the annual things you have to do for the corporation, they have the same effect. They both allow up to 100 shareholders, right? They both have the same type of dividend/distribution taxation like that. Did you have a question?
I was going to just tell folks, if you want to add a question to Slido, the access code is K251, K251, just in case. K251.
Sure. Yes.
Will it be a quick
We love
question?
the operating agreement.
Will it be a quick question? Just what
This won't be a quick question. Okay, so it's well taken. Your advice is well taken on having someone write the operating agreement. But is that a form? I'm not use the word form. Is that agreement filed with anyone,
No,
or is it just?
it is filed. It is filed in your office.
That's what I
right?
thought. Okay.
And it's meant to be
Sure.
used should one
Should
member
something happen.
need to have an issue with another
Right.
member.
I got you.
Paper trail,
Okay.
exactly.
A single
Okay.
member. It's just filed in your file cabinet.
Right, file cabinet, yes.
So one of the very, very important things, especially about your operating agreements, is don't beat around the bush. If you have other people who are going to be your business partners, write in your operating agreement, sit down and say, if everything goes to hell, what are we going to do here?
Yeah.
And in terms of voting as well, you can also give specific things weighted voting. So if a couple of your members have very, very specialized skills, you might want to take input from the other people who are your members, but actually allow that person to decide how you're going to proceed with that course of action.
And I'm going to take it a step further as a plug for Mike here. If you got a multi-member LLC and you've got some serious money or even not so serious money involved, work with an attorney. These operating agreements really need to be done properly. And if you make a mistake, it's going to cost you big time if you ever need it. So penny wise, pound foolish kind of thing. So work with an attorney, get it done right.
All right.
My attorney is really good if you need one, by the way.
All right.
My attorney can beat up your
on-
attorney.
Comment on a series LLC. Gary, I haven't set up a series LLC. I have read about them. I know a little bit about them, so I'll tell you what I know. Series LLC, to the best of my knowledge, is think of it like an organization chart where you have your main LLC and then a whole series of LLCs below it, almost like in a chain where one LLC is over top of another LLC, et cetera. And the idea is that each LLC protects the other LLC from liability for its actions, but all of the profits flow up to the main LLC. So that's kind of the idea behind a series LLC. It's almost like what we were talking about setting up a different LLC for each property, whereas you would be the top of that LLC chain, and LLC is the top of a series LLC chain. That's generally, again, I haven't set it up. I haven't worked with a company that does that, but that's the best of my knowledge what it is.
So what Larry was saying before is the other way. The other way of doing it is the LLC is at the top, and then a whole series of trusts that feed into that. Right, Larry? Yeah.
Right. All right. Incorporate in sorry, that's the last question. Do you need an attorney to start an LLC? Nope. You need $125 and a pen. Or not. Actually, you don't even need a pen anymore. You go online and you create an account on the Corporations Bureau website, and you fill out the forms yourselves. You can do it. It's not very difficult. You might run into one or two questions that you don't know the answer to, right? The attorney is not really necessary to create the LLC. The attorney is what you're going to want, as Don said, for when you're filling out your subchapter S, when you're filling out your operating agreements, right? You have to register PA 100 tax form if you're registering in PA. That can actually get a little complicated. If you don't do it right, you're going to wind up paying taxes you don't have to pay. So that's where an attorney really comes in to help. Okay, how much does it cost? How much is a car? I don't know. It all depends on what you want to buy. If you want a corporation versus an LLC single member versus LLC multi-member, there's all different types of pricing. It all depends on what you want to do. I am happy to take an email, a call, and I tell my clients I have a pricing sheet, so I don't make the numbers up as I go. Whatever you tell me, yes, this is how much it is. Okay, because I know what's involved generally. And that's for setting it up basic. Now, if you come to me and say, I want to set up, a series LLC and there's 15 of them or something like that, well, we might have a different conversation, okay? Advantages of a real attorney, versus Incorporate.com or LegalZoom or something like that. Okay. It does sound like discrimination. Whose question was that? Mitch.
All right. Well,
Mitch.
You're not invited here anymore.
All right. No. There are differences. Okay. Number one, a real attorney, right? Believe it or not, doesn't cost very much more than what Incorporate.com or LegalZoom.com will charge you. But the difference is, number one, in my world, okay, I don't believe in the standard agreement or the standard template. It's different for everybody. Okay, your operating agreement will likely be vastly different than your operating agreement because even if you're both single members or you're multi-members, you have different needs for what you want to do with your organization, okay? Number two, I actually just found this out because one of my clients had originally registered with LegalZoom, sent me an email from LegalZoom. Apparently, they charge you an upfront fee of maybe $300 or $400 or whatever it is, they charge you an annual registered agent fee as well of another $300, where if you're a Pennsylvania corporation and your business is in Pennsylvania and you work in your business, you don't need a registered agent, right? So while they're saving you maybe a couple $100 up front, they're charging you annually for something you didn't even realize you didn't have to pay for. Delaware's a different story, but Pennsylvania, you don't have to do that. And lastly, good luck getting a hold of somebody on LegalZoom when you have a particular question, something that's specific to your business, right? Right? Quality of service, exactly. Where your attorney is there and can pick up your phone and give you the answer, or do a little bit of research for you. LegalZoom will politely point you in the direction of their FAQs. Okay? All right. Partnership is like marriage. You want to know your partner well, correct? Yes, absolutely. No question about it. In fact, you probably want to know your partner in a partnership better than your spouse. Okay? And the reason you want this? You want this one? Oh, Nathan's all over this.
I want to hear why he wants to answer that.
Well, it kind of goes back to that incorporate.com. So if two people come into my office and they say they want to be partners, I'm not going to say, all right, sign here. And then give them a piece of paper and say, all right, what's the name of this thing going to be? Wet Sox. All right, fine. What's your name again? Write that down. No, we're going to have a discussion about what the business is. What do you hear a lot in these partnerships, especially with two people? It's some guy that wants to buy a house that doesn't have enough money to fix it up, but he can afford to buy it. And he found some guy who can fix it. And one guy is going to be the sweat equity. He's going to work and work and work. And the other guy is just going to have the money. This has incident written all over it. So that's going to have a different conversation than somebody that wants to sell socks. Why are we talking about socks so much? So we're selling these wet socks, and the one guy doesn't have any money, but he's great at selling socks and he loves feet. So
that's a different workshop.
This business takes off. I mean, this guy's selling socks to people that don't even have feet. He's the best salesman ever. It's amazing. And then 8 years in, this guy's like, I'm selling a lot of socks here. And the other guy, he's just sitting there counting the money. This happens a lot because people don't think ahead on it. They don't have the discussion of, hey, if you're the money guy and I'm the sales guy, what's going to happen 10 years down the line when I don't want to keep running around doing the sales and I can train other people to do it? The other guy's still just sitting there counting the money. These are big decisions and things that have to be planned out between the two people. It is like a marriage. There may not be a house necessarily or a car involved, but there's property involved. And it's not just the property. You have to be with them all the time. You have to talk to them all the time. And that's why, personally, sitting down with someone who's really going to hear your situation and individualize the product that you get, I think is very important. You can never know somebody too well because these partnerships change over time.
You can hire me to find out about them if you want.
That's correct.
Thanks for the sock metaphor, but okay.
And the other thing with that real quick is, as Nathan said, you don't know your partners very well. What if there's someone you've only known for a year or two and you get into business with them and it turns out they have a history of fraud or something like that and they rack up $500,000 in debt on your partnership and then they skip town or skip the country? Who's liable for that? You are, right? So joint and several liability. So you got to be really careful about who you go into business with. All right, our real estate LLC is more detailed than other types of LLCs. Not really. I mean, the process of setting it up is the same. It's the agreements you're going to have, assuming you have multiple members. It's the agreements you're going to have about ownership, equity, that type of stuff in the LLC. I could say a real estate LLC is probably, in that sense, more complicated than wet socks, right? We're going to keep going there. So, yeah, it can get a little more complicated only because real estate itself is a more complicated thing. So what happens if one of them is a realtor, right, and has their real estate license and can sell the property? Well, now they're making more money than the other partner, right? Maybe. So it all depends on what you want to do with it. But I could see more complications in a real estate agreement, real estate LLC operating agreement than a standard one. I did serial series, I'm assuming you meant. I guess they're called the same thing. If you have multiple e-commerce stores, who's this? Anonymous, thanks. If you have multiple e-commerce stores, do you need to mention your LLC of the website to protect company from liability? I would say, without question, at the bottom of your website, XXX LLC, right? And on your receipts, whoever LLC. And on your checkout page, whoever LLC. And just have it in their face that you're an LLC every time they're purchasing from you. That would be my recommendation. Have it at the bottom of each one. Incorporate in PA or Delaware. I get that a lot, okay? And the answer is, Susan, what's the answer? It depends, exactly, yes, okay? Delaware has some great tax advantages. It really does. But that is a myth until you're making a certain amount of money, right? I don't know what the thresholds are, but until you're making a certain amount of money, and I'm going to guess most of us here probably don't, the tax advantages in Delaware are minimal, if non-existent, if you make under that amount. But it costs more to be in Delaware. Not only the formation is significantly more expensive, but you must have a registered agent in Delaware. Even if you're in Delaware, you have to have a registered agent. And that costs you several $100s a year just to have a registered agent, amongst other things you have to file. I think, is there a minimum tax in Delaware? Do you remember? There is an annual LLC tax in Delaware, too, that you don't have in PA. So there's things like that come into play, but you have to make a certain amount of money before it becomes worth it. All right?
Can I comment on that, too?
Oh, by all means.
I've actually had LLCs in New Jersey, PA, Delaware, et cetera. By far, if you are doing business in PA and you are, as he just said, not reaching certain caps, 100% incorporated in PA. I do not recommend you incorporate in New Jersey at all unless you are actually doing business in New Jersey. And even then, I still don't recommend it. Not even kidding. Like,
you live in Jersey, too.
I do live in Jersey, too. But again, if you are relatively small or you're just starting out, I highly recommend incorporating more than likely in whatever state you are in PA, because I have actually dealt with calling the Division of Taxation, all that fun stuff. They actually answer the phone, which is really nice. Yeah. Really nice if you ever actually have to call anybody for anything.
And they know what they're talking about.
Yeah, and they actually know what they're talking about, which is really interesting.
All right, do you act as a registered agent for an LLC? We can. If you are registered in PA, I would never advise my clients that you need a registered agent. I would say, no, you don't need one. You can do it on your own. I'm happy to do it for you if you think there's a reason. Like sometimes there's a company that's actually out in like Florida or something and they need a presence in PA and they want a registered agent. I have done that and I would do that for a client. But if you're already in Pennsylvania, there's no need to have a registered agent in PA. It's just an added expense you don't need. And for those of you who aren't aware, the purpose of the registered agent is really for one thing and one thing only. When you get sued, where does the paperwork go? That's what it comes down to. All right? That's what a registered agent is. When someone wants to sue your business, they need to serve that paperwork somewhere, and that's your registered agent. That's what it's for. And I believe that's the last question.
That is the last question, unless there's... And Jay, you have another question?
What a shock.
I didn't want to monopolize this, so I saved it for
by all means.
Do you have any socks to sell?
This may be a more accounting-related question, but I'll ask it anyways, and then I can even open it up to Larry and some of the other people who can answer this. So in a real estate situation, if we do what Larry suggested, or I guess said you could do this, not legal advice or anything, all disclaimers holding, right? But if you transfer something that is that you own, like a thing that is under the bank, it's a mortgage agreement. The moment it transfers from an LLC or whatever it is into probably a land trust or trust agreement or something of sort, if it is mortgaged, the banks can invoke something called a due on sale acceleration clause. Yeah. And I think, based on my research, and please correct me if I'm wrong, in the state of Pennsylvania, if it is like an LLC and it's a land trust and it's held by the same person, you don't have to record it with the recorder of deeds. And therefore, it it doesn't become part of that due on acceleration clause. Am I right or wrong, or can anyone throw this in?
Please use the microphone.
Yeah, I am in no way qualified to answer that question. I'm sorry. Larry, if you want to answer it.
Larry, microphone. We're going to get you a personal microphone next time.
I know, I'm just trying to. What are you trying to do? Okay, so is it in your name now?
It's in my name.
Okay, and you want to transfer to a trust, and you don't want to pay transfer tax, correct? That you can do that as long as the beneficial interest stays the same. So in other words, you're now the beneficiary of the trust. There is no transfer tax. I think everything you were trying to say, that was the answer. Okay. Okay.
See, I didn't know that. It's great. Gary, did you have a
Gary,
question, sir?
did you have a question? Microphone, Gary, please.
So you're talking in Pennsylvania and not New Jersey.
Smart.
Okay, so see, you just have to understand, Pennsylvania, the Department of Revenue looks at transfers of ownership and says you owe me a tax. And so what Larry was saying to you is the beneficiary is the same, okay? They're saying whether person or trust doesn't really matter. Then that's who is in a trust. That's who has the monetary financial interest, and that's why they're looking at the beneficiary. The trustee can change, but you do have to be careful about land trusts. And tell me if I believe this is correct with land trusts. Aren't they treated in Pennsylvania as a business trust, same as Massachusetts is?
Continue to try it again.
Yeah, it's private entity, but Massachusetts is trust to be all business trust, and Pennsylvania does some of that, but I don't know if that's going to be a factor with what you have set up.
You just move it.
Keep it.
Right. There's two things. First one is, yes, if the beneficial interest stays the same, you don't have to pay transfer tax. And in case your mind went over to, can I move it into an LLC? No. If you move it to an LLC and you're a sole member LLC, you do have to pay transfer tax because it's a completely different beneficiary now.
NJ, let me just say, this whole issue, you can certainly come back to the mic, but this whole issue of trusts and deed transfers and all that, it requires an attorney who really understands their stuff, not an attorney who tells you he thinks he understands this stuff. This is not trivial, okay, all joking aside.
Yeah, and talk to a title company and verify what I said before, because I'm not an attorney or an accountant. Talk to your accountant, and your attorney, because I'm not an attorney or an accountant. But what I just told you was right.
So just by way of example, my wife and I just killed a real estate deal last week because the wholesaler wanted to do some funny stuff like wanted to do some stuff like what you were just talking about. And it just wasn't right. So you've got to be careful.
I just want to clarify this. So it's
He's on camera. He knows.
It's on camera, right? So essentially, here's what's happening. So there is an LLC. It owns 3 properties, right? So technically, the LLC's assets are the 3 properties. So if you have a slip and fall in one, all the 3 properties are under the gun. That's right. So this is what prompted me to ask the question: if you're better off in separate LLCs, then yes,
or
if
separate
you slip
trusts.
and fall in one,
Or separate
then
trusts.
it's only yes.
That's correct.
Right. So, but if you put them in 3 different trusts, and the LLC is still, you're filing only one tax at the end of the year, but if somebody comes after you, slips and falls in one, they are isolated to only one trust, or does it still spread? That's what I wanted to clarify.
Have good insurance. Jeez.
I do. I do. So that was my protection. I took like loads of liability insurance.
It's not that expensive. Insurance is not that expensive, in spite of what Mr. Mike said before. It's not that expensive.
Well, not when you're talking about property. No, $1,000 a year or something like that. Sure, $1,000 versus paying an attorney $500 to set up your LLC. That's a different story.
Yeah, but if somebody comes after you for $500,000 because they slipped in, right, it's worth it.
You want the reality to your situation, not the legality? The legality is yes. They can go from the trust to the LLC, sue the LLC, and get the other assets. Here's the reality, and just understand how I explain this to you. Okay, you have 123 Main Street Trust and Steinhaus Properties, right? So Steinhaus Properties is the beneficiary of 123 Main Street Trust. Larry Steinhaus is the trustee of 123 Main Street Trust, okay? And Mike's client slipped on 123 Main Street. What's he immediately do? He's going to look up who owns 123 Main Street. 123 Main Street Trust. Trustee, Larry Steinhaus. He's a smart guy. He's either going to write a letter or call me and say, hey, Larry Steinhaus, who's the beneficiary of 123 Main Street Trust? And I'm going to answer him, I'm the trustee. I can't tell you. And that's the end of the conversation, unless he wants to find out more and actually sue me. Now, remember, his client slipped on 123 Main Street Trust, who is hiring him on contingency. Now Mike says, wait a minute, this might be complicated. It's going to take me a long time to get to this. Mr. Client, are you sure it was 123 Main Street, or was it 124 Main Street you fell on? Or he's going to say, Mr. Client, I need a $5,000 retainer now to find out who owns 123, or who the beneficiary is of 123 Main Street. That's reality. Don't say anything, because I know you can't. That's reality, okay? Let's continue this to the nth degree. All right, now, if your LLC, if he sues me in my LLC, and I finds out that I'm the sole member of the LLC, which is hysterical, he goes, you're the trustee and the sole member. I said, no, I'm not. I said, there's a trust that's the sole member of this LLC, and that's, who's the beneficiary of that trust? I can't tell you. I'm the trustee. He's got to do it again. So when we talk about serial LLCs, this is how you solve that problem. You do serial trust. You do a trust owned by the LLC, owned by a trust, owned by the LLC, owned by an LLC in Colorado, and a trust that's in Delaware. And you can go to the nth degree, all right? And believe me, there is no attorney in their right mind that's going to chase this for a $50,000 slip and fall case. I think that's what you're trying to do. But one trust and one LLC is probably enough. You got it? And they're also not going to be able to look you up and say, look at all those properties this guy owns. We're going to sue him. You know, the answer is he might think you have one property, and if there's a mortgage on that property in the trust, he goes after the property because it's their trust. And if there's $20,000 equity, here, you know what? Here's the keys. Thank you very much, and just go and do it again. You got it? That was reality, not legality. And I would check with your attorney before you do any of these things.
Do we have any socks to sell here?
Oh, by the way, you know, I actually happened, just out of curiosity. Yes. It's been registered since 2002 by a company in London.
Did you go to their website?
So I'm not the only.
What the,
So I'm not the only crazy person. But anyway, I do have a question kind of related to that. So a lot of companies, you know, a lot of times they may want to set up websites to capture in the mistaken belief that they can capture keyword traffic by having all these different domain names, xyz.com. So there's no legal implications of somebody using a name that is obviously not their company name with the xyz.com. Wetsocks.com.
Once again, it depends. And the reason it depends is because you're starting to cross into trademark law. If you sell cars, all right, and so you manufacture cars, and for some reason Toyota didn't register Toyota of Pennsylvania or something like that, and you decide you want to use that name even though it's not your name, if there were no company called Toyota or something like that, yes, you could do whatever you want, right? But if there's Toyota and they're a registered name and they're a trademark, they could sue you for trademark infringement. Different discussion for a different time, but there are other implications besides I'm just using a DBA. right?
Okay.
If your question's just about a DBA, yes, you can use whatever name you want as a DBA. If you're going under a particular website URL, it's more about what's on the page than what the URL says, right? So if the URL is xyz.com, but you're holding yourself out as Wet Sox LLC, you're probably okay. If the URL is your competitor's name with a little bit of a different spelling or something like that, you're trying to steal their traffic, that's a trademark infringement issue.
Okay.
All right, go.
I think we're going to...
We have one more.
Oh, okay.
She was so
Annie.
politely sitting over there. One more question.
Annie will ask a great question.
Hi, I wanted to go back to a comment that someone had made previously about when you lend your business money, you can charge interest on that money, which I wasn't aware of before. If it's a flow-through entity, I mean, how, because you're deducting that from your income, but it's going to your personal...
Well, you're still going to pay, right, taxes on it, okay? You're still going to pay taxes on the interest. But if I remember correctly, and I'm, again, not an accountant, does interest go to your bottom line as personal income tax?
It did last year, but this year it may be different.
I think it changes this year,
yes,
right?
Yes, that's right.
Yeah. So you can actually wind up paying less on the interest because it's personal. It's not personal income tax anymore, I don't think.
It also depends. Is this, what's the operating agreement? Is this through an LLC?
It'd be a sole proprietorship.
Oh, that's, sole proprietorship. That's income. Sole proprietorship is income.
So that is ordinary
Yes.
income. So
I would
then
think
that
that's
doesn't,
ordinary income.
so that doesn't really benefit then if you're a sole proprietorship or partnership to charge interest to your...
Well, it could.
Well,
If you're a sole proprietor, probably not. If you're a partner, let's say you're not a 50-50 partner, right? You're a 70-30 and you're on the 30 end. Yeah, you want to charge that interest because that's your money that you gave the partnership that you should be earning interest on, and that's money that comes off of the top line of the company, and then you're not splitting that with your partner. See what I'm saying?
Okay, but in terms of a sole proprietorship, there's no...
I don't see any advantage to it. I might be missing something. I don't see
No, I think, well, I'm not a tax attorney, but you're going to probably be charged full personal tax rate.
Yeah.
Honestly, if you think about sole proprietorship, just imagine it's you. Don't even bother thinking of it as a separate entity, more or less, because that's how it's going to look for tax purposes.
Go visit an attorney quickly.
All right, everybody. Thank you very much for this evening.
Let's give...
Thank Nathan as well.
Let's give Mike a great round of applause. Thanks very much.